Good afternoon, my Real News Midday TV family. Welcome back to the channel for another news update for Wednesday, October 15, 2025. And in the news this afternoon, psychiatrists declare mother unfit for trial in infant's death. Two psychiatrists have concluded that a St. James woman accused of killing her infant daughter is unfit to stand trial. Shamoya Green is charged with the death of her 5-month-old daughter, Destiny Brown, who she reportedly threw from the roof of their Lilliput home in December 2023. During a fitness to plea hearing in the St. James Circuit Court on Tuesday, psychiatrist Dr. Maka O and Dr. Johnny Gay McCleary, both attached to the Department of Corrections, testified via video link. O, who assessed Green 9 times between May 2024 and September 2025, diagnosed her with psychosis and a seizure disorder. He said these conditions impair her ability to understand the murder charge or instruct her attorney, Gillian Horton. Psychosis includes auditory hallucinations and irrational speech. Ms. Green hears voices when in fact there is no one talking, and she has had frequent episodes of fits while at the South Camp, O said, referencing Green's detention at the South Camp Adult Correctional Facility. He said she used expletives during one interview and could not explain why she was arrested. She has no recollection of the incident. McCleary, who evaluated Green 20 times between May 2024 and September 2025, reported similar findings. She described Green as suffering from persecutory delusions and frequent conversations with unseen individuals. She has the belief that the individuals around her are constantly trying to harm her, and she believes she is always in danger. Ms. Green would constantly be having conversations with unseen individuals during our interviews, and recently she would be speaking to her children while having the interview, having a full conversation with her children who were not present, said McCleary. Ms. Green's psychosis is most of the times exacerbated by a seizure episode, she added, noting that Green has had between 5 and 7 admissions at the Kingston Public Hospital since her arrest. Both doctors dismissed the possibility that Green was fabricating her symptoms to avoid a prosecution. The hearing continues this morning when a 7-member jury will decide Green's fitness to plead. According to police reports, on December 6, 2023, Green became upset after her common-law husband refused to talk with her about their relationship. She allegedly took Destiny to the roof of their 3rd-floor home and threw the child onto the concrete pit. Destiny later died at hospital. Toots remanded following court appearance. A woman allegedly at the head of a robbery syndicate in St. James was remanded when she appeared in court on Monday. Shamara Forrester, otherwise called Toots, of a railway lane address in Montego Bay, was charged last week after the police arrested her along with 5 others. According to a cop familiar with the matter, she appeared in the St. James Parish Court to answer to the charge of illegal possession of ammunition. The lawman said investigations continue into her affairs, as the understanding is that the group which she allegedly heads is responsible for targeting and robbing several business establishments. Law leaves the judges with tough choices. Criticism of court rulings that impose non-custodial penalties on convicts instead of confinement is grounded in public ignorance of the law governing sentencing, which places judges in a dilemma, Appeal Court President Justice Marva MacDonald Bishop has explained. The issue formed a part of MacDonald Bishop's contribution to the Mona Law Distinguished Lecture Series at the University of the West Indies Law Faculty in Mona St. Andrew last Thursday. Noting that imprisonment is the backbone of most criminal justice systems, the appeal court president said there are typically strong public expectations for sentences of imprisonment in all cases, even where the law does not permit it. Addressing the theme, Heavy is the Crown, Navigating Sentencing Within a Constitutional Democracy, Justice McDonald Bishop said, "The first dilemma for a sentencing judge often arises in deciding whether to deprive an offender of his liberty by imposing a sentence of imprisonment or whether the court should impose a non-custodial sentence like a fine, community service, or curfew. Determining whether imprisonment is warranted can therefore be contentious and lead to differences of opinion among judges themselves on the one hand and the public, and not to mention the other branches of government on the other. In many cases where non-custodial sentences are imposed, judges are often seen as taking too soft or lenient an approach." She said the discourse frequently arises in cases involving motor vehicle manslaughter or causing death by dangerous driving, where fines are generally imposed. In such cases, public dissatisfaction can be considerable due to the perceived inadequacy of non-custodial sentences for serious harm. But we must note that the inclination towards non-custodial sentences is not a matter of judicial sympathy. Judges are duty-bound by statute to first have regard to non-custodial sentence options where those are available, having regard not only to the circumstances of the offense but also to the circumstances of the offender, McDonald Bishop said. She pointed out that Jamaica's Criminal Justice Reform Act imposes a statutory mandate that in all cases where a non-custodial sentence is permitted as an option, it should be the court's first consideration. Imprisonment, therefore, should be reserved as a last resort and for the most serious of offenses, the appeal court president pointed out. She, however, stated that the language of the Criminal Justice Reform Act still puts the judges in the difficult position of deciding what to do in each individual case. In other words, judges continue to face the dilemma of determining which cases are the most serious or last resort in determining what is the worst of the worst. It's a serious problem for judges because the legislation offers no clarification on what that means or what the judges should consider. But what we do know, based on law, common sense, and the plain reading of the legislation, is that the court must be satisfied that a custodial sentence is the only suitable punishment given the circumstances of the offense and the offender, she contended. That is to say, the custody threshold must be met. To make these determinations, the court will thoroughly consider all circumstances, addressing such factors as the harm caused or likely to be caused, the risk of serious future harm, the offender's age and maturity, the offender's criminal history, and the general antecedents. However, even if the threshold is met, incarceration may still be avoided through personal mitigation or the suspension of a prison term that in Jamaica must not exceed 3 years, she said. Guys, thank you for watching. See you this evening at 6 p.m. for another news update.